Okay, hi. So question 2 on the Rhode Island ballot this year will ask Rhode Islanders to reinstate the Ethics Commission's jurisdiction over the General Assembly. While that might sound like a good idea on its face, there are some free speech issues against it. So I know whenever I have a good government or a free speech question, I always go to John Marion of Common Cause Rhode Island or Steve Brown of the Rhode Island ACLU. But on this issue, on question 2, you guys are on opposite sides. You guys are on opposite sides of this issue. So let's have a talk about that. John, maybe you can start by telling us why Common Cause supports question 2.
Well, thanks for having us, and thanks for the therapy. We are normally on the same side of a lot of issues. So this is something Common Cause has supported for a long time. We supported back in the 80s the creation of a statewide ethics commission that would have jurisdiction over all 3 branches of government. We believed then, and we believed through the court case that ended with us being here today, that when this ethics commission was created, it was supposed to have a jurisdiction over legislators for everything they do. The Supreme Court disagreed with us in 2009, but in their opinion they said you can fix this with a sufficiently explicit constitutional amendment. So that's what we did. We drafted something that we thought simply restored the jurisdiction the way it was for 20 years, and that's what question 2 is in our opinion.
All right, Steve, the ACLU sees it a little differently. Tell me why the ACLU is against question 2.
Sure, our concern also sort of goes back to the origins of the Ethics Commission. The ACLU actually opposed the constitutional amendment establishing the Ethics Commission because of our concerns about the extremely broad powers that the constitutional provision gave them.
Okay.
So in layperson's terms, it would be, having an agency, an unelected agency that can serve as judge, jury, and executioner. I mean, that's the term that can be used.
Sure.
They are an agency that can adopt the regulations as to what constitutes a conflict of interest. They are the ones that hear, file charges against an individual and get to judge that individual as to whether they violated it. So that's giving an unelected agency a great deal of power, and from that crops our concerns about limiting the circumstances under which they can use it. In this particular instance, in terms of applying it to legislators, we have seen proposals in the past. The most specific ones were from Governor Carcieri when he was in the office. He encouraged the Ethics Commission to adopt regulations expanding the definition of conflict of interest, that to give examples he himself gave would have, for example, prohibited any attorney who did criminal defense work from voting on any legislation dealing with the criminal law. And our concern is the ultimate impact of something like that would be legislators could not represent their constituents in a meaningful way. Constituents who were electing representatives because of their expertise on certain issues could be barred from voting on it if the Ethics Commission were to adopt broadly worded regulations.
Sure.
So just to make clear, the Ethics Commission can't execute people. When he says judge, jury, and executioner,
you never know.
Yeah, we did abolish the death penalty many years ago. That's true.
And Steve, brings up this Carcieri example, and it has, one of the things I respect about the ACLU is there have been folks who've come out as opposing this, but the ACLU's been there all along, and they were there for the legislative hearings, and I respect their point of view, and the fact that they weren't afraid to stand up against something that people perceive as good government. To respond to that without talking over them like we saw in the debate last night, yes, Governor Carcieri proposed these things, the Ethics Commission rejected them. There have been a number of proposals over the years to really narrow or expand the definition of a conflict of interest that the Ethics Commission has rejected. And we think they would, an Ethics Commission would continue to reject that because there would be this recognition that you can't limit so much participation by public officials in their official roles as to really prevent them from representing their constituents.
Okay, so I have no doubt you two can be civil. You're setting a very low bar comparing yourself to the debate last night.
Let's not say, there's not much
Right.
there. I mean, I think the difference that shows from the way we approach it is,
Yeah.
John's position, or the position of those who support essentially is, let's trust the Ethics Commission not to go too far.
Yep.
And we start with a skepticism, don't give an agency incredibly broad powers in the hope that they won't abuse it.
Okay.
And so that's where we're coming from.
Gotcha, I like that. So let's catch everyone up to speed. I bet everyone who doesn't follow Rhode Island government as closely as you two would kind of assume that the Ethics Commission would have jurisdiction over the General Assembly. Can one of you, and I thought, Steve, you have the longer institutional memory, maybe you want
It's
to...
really John, John.
All right, yeah, okay.
Yeah, I mean, so one of the things I'm careful to point out is this restores a part of their jurisdiction. They still retain some. And it gets to the fundamental issue here, which is that there is a part of the Constitution, state constitution, called the Speech and Debate Clause, that provides a general immunity for legislators, and only legislators, from prosecution or suit based on their legislative activity.
Okay.
The Supreme Court in 2009 said that came into conflict with the part of the Constitution that created the Ethics Commission.
Yeah.
As Steve said, out of that 1986 Constitutional Convention, the Supreme Court said one needs to yield to the other, and that the more venerable Speech and Debate Clause would win the day. So what happened as a result is the Ethics Commission lost its jurisdiction over issues dealing with legislating. So if you get your cousin a job, you're still subject to the Code of Ethics. If you take a state contract, you are still subject to the Code of Ethics as a legislator. But if you vote on a bill that gives your cousin a job, you're currently not subject to their jurisdiction, the way you would be if you were a city council person or on a school committee, even though those are also a type of legislature. So that's the conflict here. That's what happened. That's why we're at the point we're at, because the Supreme Court came to that conclusion, and we're trying to reverse the outcome of that decision.
Steve, where's the ACLU on speech and debate? I was assuming you were going to come in here and that was going to be your main kind of argument for why we should vote no on questions.
Well, it is. I mean, I've sort of discussed it in a roundabout way. The whole idea of being able to represent your constituents freely without fear that you're going to be, there are going to be legal consequences for speaking or voting on issues as you represent your constituents is the essence, really, of the Speech and Debate Clause. And we are concerned that the possibility exists that could really be undermined as a result of the amendment.
But it's important to know that this isn't a repeal of the Speech and Debate Clause completely. So a legislator will still be immune from prosecution by other folks, namely the Attorney General. They'll be immune from civil suit based on their legislative activity. So the Speech and Debate Clause will remain in the state constitution as it is in 43 state constitutions. This will give a partial repeal for the purposes of ethics oversight by the Ethics Commission.
On the other hand, as John mentioned, if this weren't to pass, there's still a number of laws, regulations that still keep legislators from doing a lot of things that are improper or illegal. So it is attempting to fill in this particular area, but it's not as if we didn't have this amendment, legislators could do whatever they want, engage in criminal activities, quid pro quo stuff, willy-nilly.
What's a real-life example of how we've seen speech and debate in our political discourse, or in politics of the State House, in other words? Like, how have we seen a legislator even either in the far past kind of run up against it or not run up?
So prior to the decision, so from 86, 87, until 2009, the Ethics Commission had this full jurisdiction. And I give two examples. The best example is Gordon Fox, before he was Speaker. in a lawyer in private practice, had an agreement with GTEC that if the bill to give them the master contract for the state and to subsidize the building of their new headquarters in Providence went through, he would get more legal work. And so that someone filed a complaint, he settled the complaint with the Ethics Commission, was fined $10,000 because he actually voted on that bill, even though it was going to put money in his pocket. The other example is Reg Allison in 06-07. There was a complaint against him for participating in the legislative process with respect to a grant that then funded a nonprofit he worked for. The Ethics Commission actually found that his participation was okay in that instance, but in the course of that investigation turned up that he was hiding the money on his financial disclosure, and they fined him $6,000 on the financial disclosure issue. So there are two folks who were ultimately brought down. Steve did say, you know, there are other tools to fight corruption. The U.S. Attorney, I think, has probably the biggest hammer, although that's been peeled back a little bit by the U.S. Supreme Court recently. You know, so ultimately it was probably, we don't know about Gallison, but it'll likely be federal things that will bring him down, just like it was Gordon Fox. But the Ethics Commission, I say, was the canary in the coal mine for both of them. It said, you guys are straying from the bounds of ethical behavior, and it was able to signal that with a fine. The voters ultimately chose to return them into office, and they ultimately abused that so badly that they were chased from office.
All right, so Steve, how do we address, given that we all kind of want the same thing here, we don't want to have legislators either doing criminal things or it's just stuff they shouldn't be, getting their cousins' jobs. How should we address it if not?
Well, there were some attempts at amendments to this proposed constitutional amendment to try to at least narrow the circumstances and make clearer that legislators would be able to speak out on the floor and not face consequences from the Ethics Commission for any allegation of a violation. So we thought those were good steps, at least, in trying to limit the reach, try to protect as much as possible the goal behind speech and debate protections, but ultimately the legislature decided not to include any of that language. So it's as broad, I think, as it could be in terms of addressing the Supreme Court decision. The one other thing I would just throw out there is that there is another consequence flowing from this constitutional amendment, and that's, I don't want to call it a quid pro quo, I think that would be too strong, but the Ethics Commission, in response to saber rattling from legislative leaders, adopted a regulation just a month or two ago, barring people from filing ethics complaints against public officials in the 90 days preceding an election.
Yeah.
And we have real deep concerns about that. We think that's a significant impact on the right of people to petition their government for redress of grievances. And I think there's a legitimate debate to be had. Is that, regardless of your feelings on question two itself, is that the proper balance? Is seating one legitimate in order to get this broader goal of passing question two?
John, let me ask you two questions about what Steve just said. One, I'm interested what Common Cause thought about some of the amendments that Steve brought up, that he said the legislature didn't see fit to.
Yeah, so there was an attempt to carve out so-called free speech within this proposal. And the problem is, it's a misnomer to say that when a legislator is speaking on legislation, they're exercising their First Amendment rights. The U.S. Supreme Court in 2011 had a case from Nevada where a member of a city council asserted that they had a First Amendment right that superseded a conflict of interest law. And 9-0, the U.S. Supreme Court, written by Scalia, of all people, said that no, when you're legislating, you're not using your First Amendment rights. You're not exercising your First Amendment rights. What you're really doing is you're exercising your portion of legislative power given to you by the people.
Yeah.
and you don't have a protection from conflict of interest rules. So there is no First Amendment protection for people who have a conflict of interest. If you have a conflict of interest as defined by the law, you aren't supposed to participate. On the issue of the moratorium,
let me ask you about that. So, what do you think about that? Do legislators lose portions of their First Amendment right when they become legislators?
Well, I think John did accurately summarize the Supreme Court decision.
Yep.
I mean, but whether it technically constitutes a First Amendment violation as the Supreme Court decides it versus is there a free speech issue generally, in less technical terms, I think is the question. We believe that there is speech that's involved when a legislator representing their constituents gets up and talks about an issue. We think there ought to be some recognition of that as an element of free speech, although the court has specified that that does not fit within the First Amendment's guarantees.
Okay.
in a court that has taken the First Amendment, Scalia had a very broad view of the First Amendment in the fact that he wrote the opinion saying this is not First Amendment speech. Protected speech, I think, is significant. On the moratorium issue,
Please, yeah.
so Common Cause supported the moratorium. We did not want it to be on question 2. We didn't want it to be on the ballot because we didn't feel something of this nature belonged in the state constitution. And so we pushed the legislature to take it out. We were glad they did. And then when the Ethics Commission took it up, we supported it, as did other good government groups like the League of Women Voters and Operation Clean Government. We've seen the Ethics Commission increasingly used as a tool by political campaigns, by both political parties, to take cheap shots during election season. And we feel like it's not the forum for that, for a couple of reasons. One, they don't adjudicate these things quickly. So you file a complaint, it's not, if you file it 30 days before an election, it's not going to be done by election time. Unlike, say, the Board of Elections, which is designed, if you make a campaign finance complaint, it's supposed to decide it quickly. They have special, the Board of Elections has a special dispensation to decide things more quickly by going straight to the Supreme Court, for instance. The other, and so we didn't want to see the Ethics Commission used as a political tool. The other thing is, we don't believe it's limiting the rights of people to petition their government. There are lots of limits placed on people's rights to petition their government, including by the Ethics Commission previously. So for instance, the Ethics Commission on its own a couple of years ago adopted a statute of limitation of 6 years on complaints. That's a limitation. In the same way, it's a limitation to say on November 9th, if you have a legitimate complaint, come back after the election, file your complaint, and we'll deal with it. So we're going to disagree on this. We thought that it was worth trying. We're going to look at how it worked in 2016. And we will go back to the Ethics Commission, and if we think it needs to be eliminated or adjusted, we'll do that. And thankfully it was done by the Ethics Commission, so it can be eliminated or adjusted if need be. And it's not in the state constitution, which I think we both agree it shouldn't be in the state constitution.
And real quickly, tell me why you do disagree.
Yeah, well, John talks about being used as a political tool, but in fact the statistics that were gathered by the Ethics Commission showed that there was no increase in so-called what would be considered unfounded complaints in the 90 days before an election. There was absolutely no evidence of that. And to the contrary, our position is the 90 days before an election is when people really start looking at candidates, start trying to figure out, are there ethical problems? It's the perfect time for people to actually want to be thinking about, should there be a complaint filed? So, we don't think it's a minimal change. It's really the core time that we think people are most active in politics, most looking at a legislator's record or what they've done. So we think there is a very important element to giving people the right to be able to file complaints during that period of time.
All right. Is there anything else we have to tell Rhode Island about kind of the brass tacks or you know, like what's in there and what we need to know when we're making the decision to vote yes or no on question 2. And then I actually have an existential question for both of you.
So I'd make 2 points. One, this isn't question 2 in Massachusetts. So we've run into, the charter school issue in Massachusetts has a lot of money on both sides, and they're running millions of dollars, it looks like, of ads, including in Rhode Island, because we spill over in the Massachusetts market. So this is a different question, so ignore that. I think the voter handbook is useful, the description in the voter handbook is useful. We have a website, yesonto.ri.org, that has more information, or they can contact me at Common Cause if you have more questions about it. So I would put that offer out there, that you can gather more information if you want to from us.
We have our position paper up on our website, riaclu.org, but I think this discussion has really been very helpful in bringing the issues out.
Cool. So
Now,
indulge me in an
question.
existential question, and by that I mean I don't want a political answer. I want to know what's in each of your souls on this. So, Steve, is it?
What if you don't have a soul?
Big assumption there.
Then you have no business doing a civil interview with RI Future. So,
Touche.
Is it hard to be against ethics for a campaign? I know you're not against it.
Yeah, that's just it. I mean, if we were against ethics, then it might be hard. But we think there are legitimate issues involved in this in terms of ensuring that constituents are able to elect legislators who themselves are able to best represent their constituents. And I think that's a very legitimate goal. I certainly understand the arguments on the other side. And I don't dismiss them, because certainly the problem of ethics in our government is one that cannot be ignored. But I think it's just a legitimate difference of opinion about balancing, weighing these different issues and where the greatest harm lies.
Is it hard to explain to people?
This issue certainly is. I mean, it is very complicated, especially because our objection is not necessarily to specific language, it's much more contextual in terms of the broader powers that the constitutional amendment already gives the Ethics Commission. So yes, it's very difficult to explain.
But if anybody's skilled at explaining difficult, nuanced positions, it would be the head of the ACLU.
That's very kind of you to say.
I think taking...
Or the head of Common Cause.
Yeah, I mean, we don't necessarily take positions as often that are as sort of politically unpopular. Is that a...
That's fair enough, yeah.
And I have a lot of respect for what the ACLU does, because they do stand up oftentimes and are sometimes the sole voice on issues.
So here's my question for you, John. Is it hard to be against free speech?
So this isn't hard, because I don't think we're against free speech. I rely on what the court said, that this isn't speech as we think of speech. Common Cause and the ACLU disagree on the limits of what speech are, speech is. Certainly, I think the 2 areas we disagree most strongly are this and in campaign finance, right? So without getting too far down, a road, we don't think money is speech. They think money is speech.
Yeah.
It's an oversimplification, but that's what it comes down to with Buckley versus Vallejo.
Yeah. And that's actually something I wanted to know. I'm sure this isn't the first time you two have not seen eye to eye, or your organizations have not seen eye to eye on an issue. Another one's kind of...
Yeah, I mean, campaign finance, limits on money in politics, I think, are the other issue that really separate us. They work on a broader set of issues than we do. We're a much narrower organization, but of the big issues for us, that's the other big difference. And it comes down, again, to a very similar question: what exactly is speech? Which is something, listen, that has been, an issue in, American history for the entire history of the Republic, and it's going to be an issue going forward, in the foreseeable future. And I think they're interesting debates, and I'd like to engage in those debates because I think they're important debates. And I respect that we're going to disagree about it.
Anything else, guys?
I don't think so. I think
Well,
it's been
gentlemen,
very
this has
good.
been amazingly
discussion.
helpful for me.
Good.
I'm sure it will be for our viewers and readers as well.
Thank
So,
you.